Greetings and welcome to once again another edition of BWF Solicitors podcast. In this podcast, we share with you a short information about the most recent immigration rules. And today we will be looking at the statement of changes that has just come through, that is the HC 1118. As we know, the UK immigration rules are often changed several times a year, and that is via the statement of changes, which lists the amendments that will be incorporated into updated immigration rules on specified implementation dates. In this regards, we are looking at the 6th of April to, months ahead for the new changes to be implemented. The changes are being phased in over the next few months, that is from the 6th of April 2022. And then we're just going to quickly look at the highlights of the changes. So number one, which is very, very important that I want us all to take note of, is the children who live in the UK for 7 years can get immigration permission with settlement, either immediately or after 5 years rather than 10 years. So that depends, I will explain. So first of all, the changes that has come through is in relation to Immigration Rules Paragraph 276 ADE, that is a private life of the human rights element. Now we know that human rights got two elements, that is limbs, private life and family life. Now, if you have been in the UK and you are relying on the length of time you've been in the UK, you will be relying on your private life to be in the UK. Now, let's start with children. If a child is born in the UK to parents who are not documented, if that child lives in the UK continuously for 7 years, under the old regime, you could have made an application for the child under the private life rules to get 2.5 years leave to remain. That's limited leave to remain. He or she would have to renew and get lawful residence 10 years in order to apply for settlement, that is indefinite leave. That has changed with Appendix Private Life, that is PL, replacing the 276 ADE of the immigration rules. So the good thing about the change is that the child will no longer have to apply for 2.5 under the 10-year route, rather could apply direct to get indefinite leave if he or she was born here and has lived in the UK for a continuous period of 7 years. This is great news. The reason why this is great is that we know that when you are making an application as a parent, relying on the family life with your child, there is something called qualifying child. The child should be qualifying for you to be able to rely on him or her to do an application to remain in the UK. The definition of a qualifying child under 117, so that's section 117D of the Immigration and Nationality Act 2002, says that the child should be British citizen or settled, and that is indefinite leave, or has limited leave under Appendix EU, or has lived in the UK for 7 years. Now, the good thing about the change is that the child you are relying on, because of the reasonableness test enshrined in the rules for you to rely on a child who is not British citizen, would help, because you can make argument that because the child is settled, it will not be reasonable for you and your child to be removed from the UK. So it strengthens your position when you are making an application under family life, relying on your child who has some sort of leave. So having settled status is better than having limited leave to remain, in short. Now we move on. If a child came to the UK, we know that a child is someone who is under 18. If that child came to the UK and has lived in the UK for a continuous period of 7 years, under the current regime, that child could make an application and will be granted 2.5 years leave to remain under the private life. Now, what has changed is that this same child under the new regime could make an application, get 2.5 years leave to remain, having lived here for 7 years, and then when it expires, would renew one more time so that the child would have 5 years lawful residence and then go and make an application for indefinite leave to remain. So the difference from the old regime is that this child who was not born here but came to the UK whilst below 18 could get indefinite leave within 5 years lawful residence, as opposed to the current regime, which would have been 10 years. And that is great as well. We move on to children who came to the UK and then they are now below, they are over 18, but they are below 25. But they can show that they've spent half of their lives in the UK. They can also make an application. They will be granted 2.5, but under the old regime would have stayed under the private life for 10 years before getting settlement. The new regime says that that child or that person, if an over 18, could apply, get 2.5, renew one more time, get 5 years, and go for indefinite. This is great, and this is what we want you to take note of, that the statement of changes 1118 has brought in fantastic aspect that would improve the way that we do an application, and that will strengthen the position that the reasonable test, as is in case law, that a child who is not British could possibly be removed and live abroad with the parent, may not be the case, because if a child is settled, then he or she would have a much better claim to remain in the UK with his or her parent. This is something that we want you to take note of. We will come to you again on the same platform with further information about immigration and other aspects of the rules in the UK. Thank you very much and take care.